The last judgment being handed down this morning is in the case of Efobi against Royal Mail. This appeal raises a question about the burden of proof in cases where racial or other unlawful discrimination is alleged. The claimant, Mr. Efobi, worked as a postman for Royal Mail. He was born in Nigeria and identifies as Black African and Nigerian. He has qualifications in computing and wanted to move to a position in Royal Mail where he could make use of his qualifications. Over a period of 3 years or so, Mr. Efobi made more than 30 applications for such jobs, but in each case he was unsuccessful. He then brought a claim against Royal Mail in the Employment Tribunal, alleging that his job applications had been rejected because of his race. He also made complaints of racial harassment and victimisation. The Employment Tribunal upheld Mr. Efobi's complaint of victimisation and one of his complaints of harassment, but it dismissed his discrimination claim. He appealed from that decision to the Employment Appeal Tribunal, which concluded that the Employment Tribunal had made errors of law in its approach to the evidence and allowed Mr. Efobi's appeal. However, that decision was reversed by the Court of Appeal. Mr. Efobi was then granted permission to appeal to the Supreme Court. The main issue on the appeal arises out of a change in the wording of the relevant legislation. The Race Relations Act 1976 and legislation which prohibited discrimination on grounds of gender, age, disability, and other protected characteristics was repealed in 2010 and replaced by a single Act of Parliament, the Equality Act. The old legislation had contained provisions about the burden of proof in discrimination cases. They imposed a two-stage test. At the first stage, the claimant had the burden of proving facts from which the tribunal could conclude, in the absence of any other explanation, that an unlawful act of discrimination had been committed. If the claimant did not prove such facts, his claim failed. If the claimant proved such facts, the burden shifted to the employer to explain the reasons for its treatment of the claimant and satisfy the tribunal that race or other relevant protected characteristic played no part in those reasons. Unless the employer satisfied that burden, the claim succeeded. In the Equality Act 2010, the relevant wording was changed. In stating the first stage of the test, the old laws had used the words "where the complainant proves facts from which the tribunal could conclude," etc. This was changed to "if there are facts from which the tribunal could conclude," etc. Mr. Efobi's case was that the change in wording changed the law. His counsel argued that the change from "where the complainant proves facts" to "if there are facts" means that there's no longer any burden on the claimant to prove anything at the first stage. Instead, a tribunal must consider all the evidence placed before it neutrally and decide whether there are facts from which it could conclude, in the absence of any other explanation, that there was unlawful discrimination. In my judgment handed down today, with which the other members of the court, Lord Hodge, Lord Briggs, Lady Arden, and Lord Hamblin, all agree, I explain why we consider that the Court of Appeal was right to reject that argument. In our view, the change in wording is explained by how the law was already being applied by the courts before the Equality Act 2010 was enacted. The courts had held that at the first stage of the test, the tribunal should consider evidence from all sources, including any evidence put forward by an employer to rebut or undermine the claimant's case. The only matter to be ignored at this stage is any explanation given by the employer for its conduct. The change in wording was intended to make it clear that it is not only evidence from the claimant that can be considered at the first stage, but evidence from all sources. However, it did not remove the need for the claimant to prove those matters which he or she wishes the tribunal to find as facts. That is because There is a general rule of law in civil cases, including employment cases, that a court or tribunal may find that something is a fact only if it is admitted or it is shown by evidence to be more likely than not to be true. This is usually expressed by saying that facts must be proved on the balance of probability. The Equality Act 2010 has not changed this. It is still the law, therefore, that the burden does not shift to the employer to explain the reasons for its treatment of the claimant, unless the claimant is able to prove on the balance of probability facts from which, in the absence of any other explanation, discrimination can be inferred. A second question is raised on the appeal about when a tribunal should draw an adverse inference from the fact that someone who could have given evidence has not done so. At the hearing in the Employment Tribunal, Royal Mail did not call as a witness anyone who had actually taken the decision to reject any of Mr. Efobi's unsuccessful job applications. Instead, it relied solely on evidence from two managers who explained how the general recruitment process worked. Mr. Efobi argued that the Employment Tribunal should have drawn inferences adverse to Royal Mail from the fact that none of the actual decision makers gave evidence. In particular, he argued that two adverse inferences should have been drawn. First, he said the tribunal should have inferred that all the successful candidates were of a different race from him. And second, it should have been inferred from the fact that they did not give evidence that the recruiters who rejected his applications, which in all but two cases was done on paper without shortlisting him for an interview, were aware of his ethnic origin when they did so, because they had looked for that information which was available in an online form. This court considers that the question whether an inference should be drawn from the fact that a potential witness has not given evidence is a matter which should be left to the good sense of the Employment Tribunal to decide on the facts of the particular case. An appeal court should only interfere with the tribunal's conclusion if persuaded that it's one that no tribunal acting reasonably could have reached. In this case, the fact that none of the actual decision makers gave evidence might well have put Royal Mail in difficulty if the burden had shifted to Royal Mail to explain its reasons for rejecting Mr. Efobi's job applications. But the Employment Tribunal was not bound to draw any adverse inference from their absence as witnesses. In any case, even if inferences had been drawn that when any of Mr. Efobi's job applications was considered, the recruiter was aware of his race and that the successful candidate was of a different race from him, that would not have been enough to allow the Employment Tribunal to conclude that in the absence of any other explanation, the recruiter had rejected the application because of Mr. Efobi's race. The tribunal was therefore entitled to reject his discrimination claim. The appeal to this court is accordingly dismissed.